Parliamentary sovereignty and constitutional supremacy. These two terms are important in different constitutional frameworks or different models of constitutional law, in that they tell us both, in the different systems, where the ultimate constitutional authority lies. In other words, where the constitutional buck stops. Now, parliamentary sovereignty is associated with the Westminster constitutional system. In the Westminster system, which is that system based on the British system, and many former British colonies adopted the system when they became independent, the system has two pillars, two core issues, core concepts that you would always find in a Westminster system. And those were the rule of law, which we've discussed before, and then parliamentary sovereignty. Now, these have been said to be in contrast with one another because the rule of law is premised on the idea of constraint, equality before the law, containment of power, whereas, as you will see when we discuss parliamentary sovereignty, perhaps we are talking about power that has no bound. Okay, parliamentary sovereignty, how did it come about and what does it mean? Parliamentary sovereignty, as I said, is from the Westminster model. The Westminster Parliament in London was the mother parliament, that is, or that remains to this day a sovereign parliament, and that was the first parliament to be sovereign. Now, in the 13th century, there were assemblies and these assemblies advised the king on a variety of matters, including taxation. And the king was very fond of these assemblies because they influenced and strengthened his hand in his power battle with the aristocracy. But as time passed, these assemblies became more and more influential and eventually evolved into a parliament with a House of Commons and the House of Lords. The battle between the king and these two houses that now form parliament continued, and ultimately parliament triumphed and the powers of the king were drastically diminished. In 1689, the king's position became one that is largely ceremonial, and today's mostly ceremonial. The Queen kisses babies, gives a Christmas speech, and does things like that, but she wields no real governmental power as one would have expected a monarch of tens of hundreds of years ago to have wielded. If we look at the elements of parliamentary sovereignty means legislative omnipotence. So Parliament may make and unmake any law as it pleases. Omnipotence. And then in the second instance, Parliament is where the buck stops. There is no authority that can override Parliament's will. It is the highest constitutional authority and not subject to scrutiny. Perhaps here I should just add a footnote. This pertains only to the substance of law in a system of parliamentary sovereignty. The courts, even where you have a sovereign parliament, have the authority to question the procedure followed in the adoption of law, but they do not have the authority to question the content of the law, as that is Parliament's domain alone, to make laws without constraints. Now, as I've indicated to you, can you see that there's perhaps a tension between the constraints placed by the rule of law on the one hand, and then this abundance and exuberance of power given by parliamentary sovereignty on the other? Given the long and relatively peaceful history of constitutional development in the United Kingdom, the rule of law has become a constraint that tempers the unfettered powers of that Parliament potentially may have. So even though they seemingly are in contest within the operation in the United Kingdom, they are not conflicting. Let me go back to my footnote of earlier, just to make sure that you understand and do not confuse these aspects. Courts in a system of parliamentary sovereignty are not without any power. Courts do have the power to question laws, but they may only question the procedure. So, if Parliament has a set procedure in terms of which it must pass legislation, and it fails to comply with that procedure, then the court in a system of parliamentary sovereignty may declare that legislation to not have followed the procedure and thus to set it aside. But a court operating within a system of parliamentary sovereignty does not have the authority to question the substance of legislation. What am I saying? I cannot go to court under a system of parliamentary sovereignty and say the legislation discriminates against me because it prohibits my religion, or it profiles me according to my race, or my disability, or whatever other characteristic I may raise. Because Parliament, as the omnipotent lawgiver, may make laws on any subject as it pleases, and nothing is placed beyond the bounds, content-wise, of that on which Parliament may legislate. And this means that Parliament, in a system of true parliamentary sovereignty, may make unjust laws. Because Parliament may decide we want to discriminate, we want to infringe privacy, we want to eavesdrop and spy on all the people in the country. And if I take that to court in a system of parliamentary sovereignty and I question the content of that legislation as infringing my right to privacy, the court will simply say I don't have the authority to question the content. I can look at the procedure but not at the content. So the question thus arises, why on this good earth will any system then follow this if we know that it is susceptible to abuse? The answer is simply in the representative nature of Parliament. Parliament is legitimate because it, as the legislature, represents the interests of the citizens, and it derives its authority from the citizens, and therefore it is a reflection of the will of the people. If, in a system of parliamentary sovereignty, Parliament makes laws that are unpopular or unjust, the remedy of the people is to change their vote in the next election. There's a political sanction that causes Parliament and the majority party in Parliament to abide by the requirements of a just society, upholding human rights, because if it weren't to do that, it may find itself outside the halls of government after the next election. In South Africa, prior to 1994, parliamentary sovereignty was followed as the basis of our government was based on the Westminster model. Now, in this system, because the system only allowed for the minority to be allowed to exercise the vote, black people were excluded from participating in politics and participating in part of politics that led to representation in government. The system was inherently unjust and made unjust law in the interests of the minority. And that is because the system was not representative. So South Africa is a prime example of how parliamentary sovereignty can actually lead to abuse of power. But in itself, the system is not necessarily unjust because it's been operating in the United Kingdom for hundreds of years with success. Now, how far does parliamentary sovereignty extend? And we can talk about this in some theory, because the reality, I think, is that Parliament, even in the United Kingdom where Parliament is supreme, that Parliament is constrained by the European Convention and by the commitment to uphold and protect human rights, even in ordinary statutes such as the Human Rights Act. The first question that arises in this instance is, if Parliament is truly sovereign, in other words, it is omnipotent, it may make and unmake any law without any constraint, would that Parliament be bound by the laws of the previous Parliament? And here I want to give you quite a ridiculous example. The Statutes of Westminster were the statutes that granted dominions, of which South Africa was one, the full power to make laws with extraterritorial force. If you're not sure, make sure that you know what the Statutes of Westminster are so that you can understand this example. The Statutes of Westminster were passed by the British Parliament, and in terms of that statute, which was an ordinary act of Parliament, it said, now South Africa, Canada and Australia, you are now big and bad enough to make laws for yourself in your own parliaments that will have extraterritorial force. Now, if the British Parliament were truly sovereign, would it be possible for that Parliament tomorrow to consider a bill and pass a bill in terms of which it repealed the Statutes of Westminster, causing South Africa, Australia and Canada to revert to dominion status without the authority to make laws with extraterritorial application? In the case of British Coal Corporation, it was held that theoretically this would be the case. However, in practice, it would not be possible. So there are limitations, and the limitations are practical in this particular instance. Perhaps a more pertinent constraint, and I've alluded to these before, is the application of the European Convention. And this is also something that's perhaps in the hanging, with the United Kingdom sort of thinking about exiting the European Union. It is a signatory to the European Convention on Human Rights, and the European Convention on Human Rights sets very real constraints in terms of the exercise of power. In other words, when laws are made, there must be compliance with that international law standard. This is reflected to a large extent in the Human Rights Act, which now allows the court not to declare legislation unconstitutional, but to point out the extent of its unconstitutionality and then defer to Parliament to amend the legislation, which you can see is very different from a system of constitutional supremacy. And this comes from the other model, the American constitutional model. And the Constitution here is seen as setting a higher standard. And all branches of government, all exercise of governmental power, both in substance and procedure, must comply with this higher constitutional standard. And this is quite evident when we look at the Constitution, Article 6 of the United States Constitution. This Constitution and all the laws of the United States, which shall be made in pursuance thereof, and all the treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. So it's quite evident that it doesn't matter whether we talk about content, that is substance, or form. How did it come about? There must be compliance in the Constitution. The idea is that there must be a constitution of laws, or a government of laws, and not of men. And I have men here in inverted commas, air quotes, as you can probably hear. Now, the Section 1 and Section 2 of the South African Constitution makes it quite evident, clear, without any ambiguity, that this Constitution is the supreme law. It sets a standard that is enforceable. All governmental actions must comply with the standards of the Constitution. But obviously, I have to throw another spanner in the works and ask about individuals. Are you and I in any way bound by the provisions of the Constitution? Do we have to comply with human rights as they are set out in the Constitution? Why? On what basis? And then the last question that I want to leave you in preparation for our discussion in class is, how is constitutional supremacy enforced? What does it help us if we have a law that sets a higher standard? How do we make sure that that higher standard triumphs? That in every single governmental action, whether we are talking about service delivery in Grahamstown, textbooks to schools, presidential expenditure, parliamentary conduct. How do we ensure that that complies with the Constitution? We'll discuss that in the next presentation and in the next lecture. Thank you.